Sorry again, your friendly local constitutional coop, California. And today's subject matter is going to be how to defend yourself, challenge jurisdiction, and win your cases. And this covers things virtually across the board. Doesn't matter whether it's foreclosure, eviction, child procurement, syndicate, whatever it is they have, because we have rights. And they don't think so. That's what you're going to learn. They think we're dead entities that have no rights. The de facto national socialist government is bound to respect. But you get my information and my document packets and send me an email, youwinnincourt@gmail.com. And we put up a fight here. And back in the day when I started out decades ago, you put documents in, and very often cases did in fact get thrown out because the DA couldn't answer them. And at the time, they didn't know what to do. I guess they went to some seminars and learned, and things got worse and worse as time goes on, and you get more and more government control over everything. And now they don't think they have to answer our unopposed pleadings. Yet the Supreme Court has ruled that jurisdiction can be challenged at any time. Albrecht v. United States, 273 U.S. 1, Yakis v. U.S. 321 U.S. 414. And even better for us, with the DA having the burden of proof when they file a claim, they're required to file proof of jurisdiction with the court that they have it. If they don't, what the Supreme Court says should be a neutral magistrate has the sworn duty to throw the case out, initially maybe without prejudice so they can bring it again. If they do it again, it's with prejudice. And that's what should be happening every time out. They throw the case out and you walk away like we're supposed to be able to do. And you get my paperwork, you're going to find out I say it with attitude and with authority. Mostly from the framers, those racist framers, from the U.S. Supreme Court decisions and other historical factors that figure into play here. We're not making this up. When we go in and say, for example, that the state of California doesn't exist, not only can we prove it, I have personalized evidence in my own case from the friggin' California Supreme Court and Tony Contil Sapoy, Filipino who should never been on the court, and they deny my habeas corpus courtesy of a deputy clerk of court who can't exercise the judicial power of the state of California if it were in existence. It's not. It's a federal insular territory, and that's the same no matter where you are throughout the country. No states, territories. It's a great subject matter to learn about, and that's one of the things when I finally got a full understanding of it, that's when the dots started to connect and line up. And that's what I want to teach you to be able to do. So send me an email, youwinnincourt@gmail.com, and you'll find out, among other things, by the way, the major big deal across the board here, the money issue. Surprise, surprise. And the problem with that is that you get into the courts and they want filing fees and forms and this, that, and the other. Well, fine. I have a specialized document that you get from me called Define Dollar. So you go in there and they want you to pay a filing fee, and it doesn't matter how much it is. And by the way, they can, as the Supreme Court once said in 1865, Crandall v. Nevada, 6-12-35. If the government can tax a man $1, they can tax him 1,000. So the filing fee in traffic court, even if it's $5 or $10, could be a whole lot more than that. But the big deal is when you pay that without raising any objections, they think you volunteered under federal regional martial law rule. And therefore you become a hypothecator of goods or stipulator in the admiralty. See you later. Have a nice day. Not how it works for us. Because if we go in there and we want to know, for example, in California, and this works, by the way, I've said this in open court in front of a black robe bastard who kind of one of the good ones, actually, because we get to the end of the case where I couldn't appear. It was a jaywalking case, crying out loud. And I told him up front, I can't appear here because that's going to give you jurisdiction. So the cop testifies, and actually a pretty decent cop in this particular case. That doesn't always happen. So I get convicted, this, that, and the other. And the judge looked at the papers and adds it all up and says, well, it comes out to something like $120 without skipping a beat. This is what I want to teach you to do. I said, fine. Can you define dollar pursuant to Section 6850 of the California Government Code that identifies money of account as a dollar, cent, and mil without skipping a beat? I went on and I said that statute was reenacted from the California Political Code of 1852 verbatim. In other words, what it means, in 2014 is what it meant in 1852, and without skipping a beat. And I said the definition of money at that time could be found in the Coinage Act of 1792. Years later, I'm still waiting to get a bill. They can't do it because if they do that, that admits that the money of the town here isn't gold or silver coin, yet we have Article 1, Section 10 of the U.S. Constitution. No state shall make anything but gold or silver coin a tender in payment of. Simple as that. And yet there are no gold and silver anywhere. There doesn't need to be because we're not in a sovereign, independent state. We're in a federal, insular, territorial possession, and you might be completely controlled by the president acting as commander in chief of the armed forces. Inc. To learn all about that, it's absolutely stunning. And I didn't start out with that mindset. I got into it. I finally figured it out. I'm going to help you do the same thing. And not only does that make you very, very difficult to beat, you might get cases thrown out here. And this is also going to be good for your children and your posterity. But if they proceed with an unopposed record of the type we can set, this is where they're going to get into big trouble because without jurisdiction and venue, and they had the burden of proof clearly and unambiguously to set that up. And think about this. If we don't know if we're wrong, let alone why we're wrong, how do we consult our representatives and or nominate and elect those who will make changes? What does that say about elections? Send me an email, youwinnincourt@gmail.com. What you'll learn about that is I can prove a cappella off the top of my head. We haven't had an lawful election anywhere in the United States since very arguably November the 5th, 1860. Wow. And there's those four magic words, and they ain't due process of law. Ain't full of consent of the governed. Where the hell is it? It's nowhere in sight. Every law in the books they have, in addition to that, by the way, is a bill of attainder, the taking of life, liberty, or property without judicial process. They're in one of their BS administrative tribunals, and you got a black robe bastard up there on the bar, and you got a law enforcement thug, and you have a DA, and the DA and the judge are also required to be state bar association members, otherwise known as unregistered foreign agents of the City of London. And you see anybody like that in the courtroom, they're not in a judicial court. And the paperwork that you're going to get from me at a very modest cost, and by the way, send me an email, youwinnincourt@gmail.com, spells it out with attitude and with authority. And best of all for us, the current justices on the Supreme Court are ending their fourth term of an all-out assault on the administrative state that threatens you every day. And when they get back, there's every reason to believe they're going to be able to hit full speed and really get out there and do us a lot of good. And it'll be plainly obvious when that happens. And that really is good news because we get rid of all this crap, all of our arguments work, and now we have an unopposed record in the trial court. And if we're forced to file a BS civil rights claim, because they think you need a statute in the fucking courts, which we don't. Justices know that. Justice Story, who was the greatest expert on the Constitution, Story commentaries knew it. The framers knew it. We don't need a statute. So we get in there with the common law action, plus has to be at arms by force of arms, and what we do is they're going to get proper service process. They never do that to you, and you'll learn all about service process too. Send me an email, youwinnincourt@gmail.com. They can't even serve you. That's how ridiculous this is. But that said, we set this unopposed record, and we're going to serve them properly. But we're also going to give them a motion to strike every pleading they put into the judicial court that we're going to be in. They don't have standing there anyway. Even if they did, they had a full and fair opportunity to do their sworn duty, and they didn't do it. They got nothing to say here. Can you say multi-million-dollar default judgment? And the reason for big numbers is that they've actively aided and abetted a court, aka administrative tribunal, to exercise jurisdiction. All these official actors know damn well doesn't have it, and have prevented us from reaching a judicial court to which we have the right from day one. What does the U.S. Supreme Court say about that? Cohen's v. Virginia. Oh, that's one of those old Guinness cases. They don't use that anymore. Hell, they don't. The justices know this case very well. A key quote here, verbatim off the top of my head, and they said it, is that the court must exercise jurisdiction. If it hasn't, it can't exercise jurisdiction. If it doesn't, the one or the other is treason to the Constitution. Simple. So they want to roll the dice. You've got the loaded one now, and we should have the loaded ones. And if nothing else, we can put a lot of these batches out there in close proximity to sell 2455 and send Clinton on death row. And happily for the mortgage bankers and for the landlords, quote unquote, they won't be homeless, will they? Like so many of their victims. Of course, they're going to get 2,000 volts in the fullness of time, but they won't be homeless, will they? That's the power the framers gave us, those racist framers, when they set up this government in 1787. And it wasn't perfect, no one's saying that, but the best government ever. We want it back. We can go from there and make changes. And I'll teach you how to do that too. Send me an email, youwinnincourt@gmail.com. But it's all in our favor, and I want to help you, your families, and your posterity. That's a winner chicken dinner, any judicial setting. We're never going to see a jury because of it, by the way, and I would love to see one. It's not going to happen. They're going to get the checkbooks out, pay us off a lot of money to shut you up from talking about it, and to not file charges of treason against them. And I think we're real close to being able to do that. That's the really good news. We'll see when the Supreme Court gets back next term. But if that starts working out and people start going to jail, thank goodness, and they can let a lot of people out of jail who shouldn't be in there to clear up some space so these bastards can get thrown in the same jail cell that these people left. That's wow. So anyway, it's all good news for us. We just have to act together, work together, study together. We can get it done. So send me an email, youwinnincourt@gmail.com. Remember to subscribe, tell your friends, get the word out. The quicker we start to take action, the faster we get the job done. Thank you.